Companies and estate planning, understanding company continuity after the death of a shareholder or director. How business structures outlive their members and what you need to know about succession planning. A company's status as a separate legal entity ensures its survival beyond the lifespan of its human members. While the death of a shareholder, director, or officer triggers administrative changes, the company itself continues unaffected. However, careful planning is required to manage share ownership transitions, decision-making authority, and financial obligations. Here's what every business owner needs to understand about post-death corporate governance in cases of share ownership versus company assets. First, assets remain corporate property. Company assets never form part of a deceased shareholder's estate and cannot be gifted or otherwise dealt with in their will. Second, shares as estate assets, only the deceased's shares in the company, as opposed to the assets owned by the company, are governed by their will. Second, executor authority estate executors or administrators temporarily exercise shareholder rights during the estate administration phase, making executor selection critical to protect other stakeholders' interests. In cases of share class nuances. First, variable rights. Different share classes may have death-triggered provisions, such as value depreciation or control shifts. Second, succession planning next-generation shares might automatically gain voting power, requiring constitutional review. Third, it is important to review each company's constitution to check what will happen on the death of a shareholder to the shares and their voting rights, so you can plan accordingly. In cases of joint shareholdings, it's important to understand how voting rights work. Many constitutions grant the voting rights to the first-named joint owner. What this means is, if the deceased's shares cannot be divided equally between the number of beneficiaries, then some may be held jointly, and the voting rights attached to those joint shares may only be able to be exercised by one person, the first-named owner. That person might then be able to control the company, to the exclusion of the other beneficiary or beneficiaries. Now, this problem can be dealt with by issuing additional shares to ensure that there is a number that can be divided equally between the intended beneficiaries, or by ensuring that there is power to do that after death. Problems can arise on the death of a sole shareholder and director. One major issue is decision paralysis. If the sole director and shareholder has died or become incapacitated, no decisions or actions will be able to be made or taken until a grant of probate has been made and the executor or administrator is able to appoint a new director. So, what are the solutions? Well, you can appoint an additional director and have the company execute a power of attorney in favor of someone else. When it comes to loan account management, there are a few risks to keep in mind. One is the automatic repayment risk. Executors have a duty to call in or realize the assets of the estate. If there is money owing to the deceased, then the executor has a duty to demand immediate repayment of the loan. This could cause problems if the company is then required to sell assets, which might trigger capital gains tax or other losses. So, what can you do? Possible solutions include ensuring the loan agreement is documented and specifies alternative terms for payment in the event of the death of the lender, or making sure the deceased person's will authorizes the executor to delay enforcing repayment of the loan. Right, so let's run through a proactive planning checklist. First, review the company constitution. Then, identify death-triggered share changes and, consider possible complications if the total number of issued shares can't be divided equally between the intended beneficiaries. Next, review the directorship structure and make sure there are multiple decision-makers in place. It's also important to review loan documentation and formalize those repayment terms. Don't forget to review executor selection. Choose executors who are really aligned with your business interests. Finally, review the provisions of the will and make sure your estate plans are aligned with corporate governance rules. In conclusion, effective succession planning requires, a good understanding of share structures, the provisions of the company constitution, and a few other important matters. Regular reviews with legal and financial advisors can help prevent operational disruptions and, of course, ensure the interests of your beneficiaries are protected. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers led by our founder Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. You can visit www.mjmlawyers.com.au to book an appointment, or just call +6 1028 808 9339. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.